Attorney General.
Thank you, Madam President. Madam President, I am very pleased to draw a conclusion to this motion that we have before us, which is to adopt these amendments coming from the House of Representatives. I wish to thank all honourable senators for their contributions today. Certainly we've had quite an amount of passionate contribution on obviously what is a very heartfelt issue. Madam President, this is about balancing of rights. This is about where we stand in our society at present, a democracy of our kind, in our situation, in this country. This is not, with the greatest of respect, something that is uncomplicated. This is about an amendment to existing law. This is about the rule of law. I don't consider that a lofty objective. I consider that the core of what this debate is about. There's a separation of powers. Anything that we do under the Constitution as the supreme law under Section 2, anything that we do in pursuance of Section 53 of the Constitution as we make laws for the peace, order, and good governance of our society, the constitutionality of all that we do is to be interpreted by a court of law under the separation of powers principle. They interpret the law, they consider what is passed here. So permit me, Madam President, to address some of the issues raised in the contributions of my learned colleagues, and I will begin with Senator Wade Mark. Senator Mark made the opening contribution that the Attorney General is upset with the opposition. Senator Mark then said that it appeared to be the government's intention and the Attorney General's intention to gut, slaughter, and attack fundamental rights. Senator Mark then called for the one-man opinion, as he put it, of Fayed Hussein Senior Counsel to be tabled, and he asked for the CPC's opinion to be tabled. He asked for Senior Counsel Gaspard's opinion to be tabled, and that of Queen's Counsel Jenkins to be tabled. I respectfully don't stand before you as a junior counsel saying my senior said. As Senator Choate alluded to in terms of the contribution, I know she didn't mean me, the Honourable Senator. I'm sure she was addressing the argument itself. I took it that way. I thank Senator Choate for a very passionate contribution today. Certainly I listened with great intent and enjoyed it. But I'll explain why we will not table the constitutional opinion, and that is quite simply because we have had an experience in this country of going to our courts. We have had a fellow named Anand Ramlogan and a fellow named Gerald Ramdeen who have sat and passed laws to amend the Bail Act, passed those very laws to create the child rehabilitation centers, and then those same individuals, armed with opinions that the state produced, then went to court to challenge the very laws that they had passed. We have a system, in fact, under our public health regulations and in laying opinions, the UNC has been to court 9 times and lost all 9 matters. And the simple point to put is, if and when we ever get to a court of law, assuming that there's support for this amendment today, we'll deal with that in court. I cannot and will not table the amendments, the contributions coming from the Director of Public Prosecutions, simply because they concern matters of national security. In the correspondence is addressed issues of national security. And why I drew the comment from Senator Choate's contribution about a junior counsel saying, "My senior tell me so," it's because the DPP is no senior counsel leading the Attorney General. The DPP has an obligation to inform the Attorney General, who has the task of amending laws, what his position in relation to laws is. And then the Attorney General, in exercising his own discretion and in taking matters before the Cabinet, brings before the Parliament laws which are approved by the Cabinet. So this is no case, Honourable Senators, of "my senior tell me so." This is a case of discharging the constitutional remit that I have as the Attorney General and as the Minister of Legal Affairs of the Republic of Trinidad and Tobago. Madam President, Senator Mark said that there's a right to privacy and that it's fundamental. And in holding on to Senator Vera's contribution, I'd like to remind that the right to life is equally fundamental. And Trinidad and Tobago, in wondering, as our citizens are asked to wonder, asked to make inquiry as to what this law is about for them, this law is designed in its legitimate aim and in the rational connection of the amendments to that legitimate aim and in the proportionality of those amendments to this legitimate aim to safeguard a number of aspects. Firstly, the right to a fair trial. Secondly, the upholding of the rule of law. Thirdly, the protection of lives. What is the first aspect of the right to a fair trial? It is ensuring that there is an admissibility of evidence. Because right now, Section 17 and Section 19, as they stand in the law without amendment, are unconstitutional. Section 17 and 19 cause an ouster of the court's jurisdiction because it says sensitive information, which is anything which will reveal the making of intercept evidence, who made it, the method, etc., shall be admitted into a court of law without inquiry. Now, Senator Hussain made a very unusual contribution as it relates to sections 17 and 19 in the amendments that we cause here in this motion. Senator Hussain said that he read the sections that said we still use the word shall. Yes, Madam President, we do use the word shall. But what we are putting into the words are shall subject to the court's consideration of the interest of justice. And 17B and C set out that the subject to the court's consideration of interest of justice and any application for disclosure of sensitive information must be met by a consideration of criterion. And 17.2c sets out the Bailey principle criterion. So unfortunately, it appears that Senator Hussain has quite simply just not read the bill. That shall is not an automatic shall with an ouster of the court's jurisdiction. It is a discretion which is subject to the court's consideration of interest of justice, and under 17.2c, the Bailey principles, similar under Section 19. Senator Hussain made a very unusual statement. Senator Hussain said that we should look past Surat as it relates to the motion before us. I, of course, put on the record that in Barry Francis and that in Surat and that in Northern Construction, we were reliant upon Lady Baroness Hale's submissions in the Surat case, and I made the point that Surat stands as the current supreme case standing in our jurisprudence coming out of the Privy Council. Senator Hussain said that Barry Francis applied, but he forgot to tell us that he was relying upon the minority judgment in Barry Francis, not the majority judgment which was delivered by Mr. Justice of Appeal Nolan Beru. Senator Hussain then went further to make a most remarkable submission that the case of Hines and the Queen stands superior to Surat. Let me remind Senator Hussain that Hines and the Queen is a case 1977 AC 195, and that Surat was a judgment 2007 71 West Indian Law Reports 39. In other words, the 2007 judgment, which dealt with the case, is obviously the leading judgment, not the minority decision of Jamada and Chief Justice Ivorachi, and not the 1977 appeal cases in Hines and the Queen. Senator Mark made a spectacular reference to the case of Malone, which is the European Court of Human Rights 1984, and as he glibly read from that judgment, forgot that the United Kingdom passed the the RIPA legislation in the year 2000. In other words, then, it is not applicable because the Regulation of Investigatory Powers Act 2000 came into effect long after the 1984 case. It was that kind of frolic that Senator Mark took us to as well and upon. Senator Mark made some very bold assertions about the case of Big Brother. Senator Mark, in referring to the Big Brother Watch and others versus the United Kingdom, swept into that case as if that case had persuasion in our jurisdiction. Because what Senator Mark did not tell us is that that case concerned bulk collection of data. Let me repeat that. Bulk collection of data, where the collection of data was not circumscribed by Section 6.1 and Section 6.2 considerations in our law. Our law does not allow for bulk collection of data. Our law specifically says that we must consider the collection of data or communication in unwarranted circumstances. In Section 6 of the Interception of Communication Act, Section 6.2 says specifically that a person does not commit an offense if if the communication is intercepted in obedience with a warrant issued under Sections 8 and 11, or communication is intercepted by an authorized officer. And here these touchstones in the interest of national security, for the prevention or detection of an offense, for which the penalty on conviction is imprisonment for 10 years or more, and includes an offense where death, imprisonment, or for the remainder of a person's natural life or life imprisonment is the penalty fixed by law, or for the purpose of safeguarding the economic well-being of the state, or for the purpose of giving effect to the provisions of any international mutual assistance agreement. Senator Choate asked us for a touchstone for the amendments that we cause in Clause 7 and in Clause 6, saying that there was no reference to what economic interest means or what national security means, quite properly pointing out to the fact that it is broad. I agree with the Honourable Senator, but the touchstone is right here, passed in 2010. Section 6.2 of the 2010 Act, which we have operated under for 10 years straight, has that touchstone. And where does the touchstone come from? The Regulation of Investigatory Powers Act 2000. That touchstone comes from the United States model. That touchstone comes from the New Zealand model. That touchstone comes from the Australian model. And all of them have the very broad concepts of law. Are we bettering those broad concepts in seeking to cause the admissibility of evidence is the question. Because what is this bill at its core? What are these amendments in the motion are at core as we seek to amend Clause 7, Clause 6? We are seeking to allow for the admissibility of evidence in very careful circumstances, where we do that under the separation of powers principle, where we feed the lofty concept of due process and rule of law. And those are not things to be trivialized. In a parliament such as ours, we must have regard to the rule of law and to due process and to the balancing of rights. This country is under siege. Section 13 of the Constitution, where you're seeking to intrude upon 4 and 5 rights, says that it only stands under 2 grounds. If you have a 3/5 majority of the members voting, and importantly, Section 13.2, if it is reasonably justified in a society such as Trinidad and Tobago. Now, what could be unreasonable in a society such as Trinidad and Tobago in saying that a prison must be a prison? What is unjustifiable in a society such as Trinidad and Tobago in saying that you ought not to have the ability to use any device inside of a prison? We passed the law. We passed the Miscellaneous Provisions Law Enforcement Officers Act, number 25 of 2019. We passed that law, and yet we know that in the prisons we have these things. And Senator Haynes made a remarkable submission that we are trying to give an executive, a failed executive, as she put it, the Honorable Senator, more power. This is not a power for the executive. It appears that the Honorable Senator has not read the motion before us. This is the power for the courts, exercising their consideration as to the admissibility of evidence under the Bailey principles set out in law in the bill, in the new section 17(2)(b) and 2(c). It's not an executive exercising that consideration of admissibility. It's the courts of Trinidad and Tobago and perhaps the Privy Council itself as the highest court of our land. Madam President, I want to put on record that the Big Brother Watch and others versus the United Kingdom is the exact opposite in terms of relevance as to what Senator Mark said. It is just irrelevant because nothing in this law is treating with en masse data collection. That was done under Cambridge Analytica by a different government, if you believe what the British House of Commons and the United States Senate has to have on its records, coming from Christopher Wiley. So, Madam President, Senator Mark's submission is not only irrelevant, but it is entirely dangerous in its purport. Madam President, we had Senator Hussain telling us that this law is too wide, that there's a disproportionate effect. And I'd like to say that, most respectfully, I think the Honourable Senator gave some good batting, tried to raise the minority judgment in Francis, but unfortunately, that just does not apply to our particular setting. I believe, Madam President, that this law is entirely about balancing the scales of justice. This law is about correcting an unconstitutionality which exists in the current law. You cannot separate the court from a discretion. You have to allow for the consideration of admissibility of evidence. This law is not about creating an intrusion upon the media. That happened in 2010. That boat sailed already. Section 6(2) of the 2010 Act allowed everybody to be intercepted in non-warranted circumstances. In considering the Bailey principles and the proportionality and gravity of the offense considerations that we've put into the statute, obviously you can't be on a fishing expedition. Obviously you've got to explain why it is your warrant was not taken. Obviously, you've got to consider the rights of journalists. When you're looking at the words actually say in section 17(2)(c), it must be proportionate to the gravity of the offense. Which court in Trinidad and Tobago is going to watch the legitimacy of journalistic purpose in relation to whether a journalist or a politician received a phone call from the prisons, as I have received phone calls from the prisons back in 2015, and say to them that that is something that they're not going to consider in the admissibility of evidence? But Senator Richards, most respectfully, who sits with Senator Vera and I on the cybercrime legislation, what exactly is a journalist? Who is a journalist? How do we create a journalistic exception in this law? We can't do it in cybercrime because the journalists won't tell us who a journalist is, but we just had Mr. Justice Ramcharan tell us in a case now completed where an ex-minister named Devant Maraj alleged that he was a minister. We had a court telling that person that you're not a journalist. So that is something which is very hard to determine. But more particularly, the amendments before us don't concern that, because that was not a feature of the law. The Parent Act treats with what the exceptions are. The Parent Act says how long a Section 8 or Section 11 warrant is to survive, how many hours, when it is renewed, what the authorized officer must do. I would find it very curious that the DPP could have a power as an authorized officer to intercept Senator Choate. I don't think that that would fit within our constitutional structure to have a prosecutor have the power to be an intercepting officer. That would run afoul of investigations. The prosecutor, yes, please.
On the contrary, the Director of Police Complaints, of the Police Complaints Authority, can be an investigator. Why was that consideration not given to that?
I see. Forgive me if I got it wrong, Senator Choate. I assumed you were talking about the Director of Public Prosecutions. It is the Director of Police Complaints Authority. Yes?
Yes, that had been my original contribution. Yes.
I took it wrong. I apologize. Well, it would make sense because I found it unusual that the Director of Public Prosecutions could be there. The Police Complaints Authority have actually asked for certain amendments to be included. What happened with the Police Complaints Authority is that they entered into a memorandum of understanding with the Commissioner of Police so that they could actually request investigations and particularly pass certain matters to them. We were wrestling with the authority of police power and the lack of a public service commission backing with the Police Complaints Authority. So we were fighting with the constitutional backing. We allowed the constitutional backing to prevail in the Chief of Defense Staff, the Commissioner of Police, and the Director of the SSA, in the circumstances that that was produced. The Director of the SSA went in the 2010 amendments. That may be something that one has to have a view of, but the Police Complaints Authority, from a constitutional perspective, we've not figured that out yet. Part of the recommendations were making the Police Complaints Authority policemen, so that therefore they could have the police complaints backing of the Service Commission aspect. A touchy constitutional issue which we're trying to solve. I want to state that this law does not touch on concern retrospectivity. We were very careful in the application section as it relates to the amendments before us to say that this law only saves or acknowledges the validity of warranted material produced under the Proceeds of Crime Act, production orders, I mean there, warranted under Section 5 of the Indictable Offences Preliminary Inquiries Act, and warranted interceptions or productions made under Section 6 of the Indictable Offences Committal Proceedings Act. If a trial has begun, then you are out of the door. But what this does, Madam Speaker, these amendments before us, in amending via Clause 6 and Clause 7, what we propose here now, we are allowing for the admissibility of evidence to come in. If we don't do this, there is a risk that all of the intercepted material that is going to be challenged in court can be viewed to be inadmissible, or if they were made admissible, to have the convictions overturned on the basis that there was a breach of the right of the accused to a fair trial. And most respectfully, Madam President, I cannot, as a responsible Attorney General, having heard from the DPP, having heard from Queen's Counsel for the DPP, having considered what I heard and formed my own view, I cannot respectfully observe this position and not take a legislative step under the supreme law of the Constitution, pursuant to Section 53 of the Constitution, to make orders, laws for the peace, order, and good governance of our society. Because, Madam Speaker, Madam President, that would be to allow criminals a get-out-of-jail card. Not that people aren't innocent until proven guilty, not that you are not in the position of allowing for an acquittal to happen, whether on the matter itself or on appeal, but specifically because
Attorney
you
General.
have to have a fair trial.
Attorney General, you have 5 more minutes.
Much obliged, Madam President. Madam President, I want for the record, in looking at the amendments before us, to point out that the case of R.V. Sanj, S-A-N-G, which is a case 1980, appeal cases 402. The question whether or not an offense was committed in the course of obtaining evidence by intercepting a communication by post or by means of a public telephone system is, in the absence of a statutory provision to the contrary, irrelevant to the admissibility of that evidence. That is very germane to our situation in these amendments before us, because we are proposing specific, yes please?
Seek to make the point. Thank you for allowing me to do so. Sang is a case which says that nonetheless it is admissible depending on the discretion of the court.
Exactly. I was about to come to that point, but to point out that we have a statutory provision to the contrary. Our statutory provision to the contrary is in Section 17 and Section 19. And therefore we must treat with it statutorily, which is what we're doing. So Senator Choate has assisted me in making the very point that I was about to make. Because the case that I've just referred to speaks in the absence of a statutory provision. But I also want to note that in New Zealand, in Canada, and in the United Kingdom, the ability to obtain interception is an administrative function, not a judicial function. And in Trinidad and Tobago, we have a judicial function for warranted evidence, and for non-warranted evidence, we have an administrative function. That's the authorized officer. And what we say is, we are not the United Kingdom, New Zealand, or Canada. And we don't leave it there. We say anything obtained by that method of an authorized officer must be subject to the jurisdiction of the court. Because that is critical. We cannot allow a member of an executive to reach into the SSA, to have an ability to know what interception is going on, and not subject it to the best form of scrutiny in a democracy, an independent court, right up to the Privy Council. So what we are doing in this law, we are underwriting the constitutionality of laws. We are preserving due process. We're preserving the right to a fair trial. We are saving this 2010 law from collapse. Now, Senator Wade Mark tells us the opposition will not support this. The opposition did not support this law with a 3/5 majority. Full stop. Senator Mark and all senators on the opposition bench, Senator Sobers, as he runs for San Fernando West, is on record as saying he will not support making a prison by not supporting the law with a 3/5 majority. So today, respectfully, Madam President, do we really need to hear Senator Mark threaten us? He didn't support with a 3/5 majority, and he didn't support without a 3/5 majority. Same old, same old. Madam President, this law is about saving lives in a careful, constructed balance of proportionality. This law is about saving constitutionality. And therefore, I recommend to all senators, as we consider our positions on this law, that we find support for what is clearly underwritten as within our constitutional structure for the amendments that we bring from the House of Representatives. I beg to move.
Honourable Senators, the question is that this Senate agree with the House in the amendments to clauses 2, 5, 6b, 5, 7, and the preamble of the Interception of Communications Amendment Bill 2019. Those in favour say aye.
Aye.
Just one second. It is let me just restate what I said before. Honorable Senators, the question is that this Senate agree with the House in the amendment to clauses 2, 5, 6B5, 7, and the preamble of the Interception of Communications Amendment Bill 2020. Those in favor say aye. Aye. Those against say no.
No. Division.
Mr. Khan.
Honourable Senators, we will await the arrival of the other senators. I believe I had said 3 minutes, so 3 minutes will start from now. I will ask all members when you're entering to enter in silence, please.
Mr. Khan.
Yes.
Mrs. Gopi Schoon.
Yes.
Mrs. Batiste Primus.
Yes.
Mr. Rambarat.
Yes.
Mr. Sinanan.
Yes.
Mr. Moses.
Yes.
Mr. Hussein.
Yes.
Miss West.
Yes.
Miss Cox.
Yes.
Mr. De Freitas.
Yes.
Mr. Singh.
Yes.
Mr. Cummings.
Yes.
Dr. Henry. Yes. Mr. Dookie.
Yes.
Mr. Williams.
Yes.
Mr. Mark.
No.
Miss Haynes.
No.
Miss Amin.
No.
Mr. Hussein.
No.
Mr. Sobers.
No.
Mr. Richards. Miss Chotesi.
Abstain.
Mr. Vieira.
Yes.
Dr. Dial Singh.
Abstain.
Miss Dionarine.
Abstain.
Ms. C. Prasad,
Abstain.
Mr. Timal,
No.
Mrs. Thompson-Nai,
No.
Dr. Dylan Remy. Madam President, the results of the division are as follows. 16 senators voted for, 7 against, and there were 6 abstentions.
Honorable Senators, the result of the division is as follows. 16 senators voted for, 7 voted against, and 6 senators abstained. The amendments have therefore been accepted.
Bill, second reading.
Attorney General. But could you desist? Thank you very much.
Thank you, Madam President. I beg to move that a bill entitled An Act to Establish a Council for Urban and Regional Planners and to provide for the regulation of the urban and regional planning profession and for other matters incidental thereto be now read a second time. Madam President, it seems that I live in the Senate as well. It is a pleasure to bring this bill from the House of Representatives and note that on Friday, 15th of November 2019, we considered the 61 clauses brought before us now. We made certain amendments to this bill, and we now come before the members of the Senate to ask for their consideration for the passage into law of this bill. This bill, the Urban and Regional Planning Profession Bill 2019, is squarely seated in Act number 10 of 2014. That act is the Planning and Facilitation of Development Act. That act is an act of Parliament of 2014, which was passed in 2013 and which was effectively proclaimed in 2015, partially and only as to a few of the sections. This law, the Planning and Facilitation Development Act, this bill, the Urban and Regional Profession Bill, Planning Bill, are intimately associated with the Local Government Amendment Bill, intimately associated with the existing laws of development and planning as we have in the transitional sense of it, our Town and Country Planning Development Act of 1960, Chapter 3501. It is integrally associated as well with the amendments that we have done in causing a real estate agency sector to be managed by the Real Estate Agents Act. In the bill which we are discussing still in the Senate, the Registration of Deeds Bill, the miscellaneous provisions, it is rooted to the Registration of Title to Lands Act, the Land Adjudication Act, the Land Tribunal Act, and the amendments to the state suit legislation professions. Also attached to this include engineering profession, which is an act passed number 34 of 1985, the Architecture Profession Act, passed as an act in 1992, and the Land Surveyors Act, passed as Act number 33 of 1996. Permit me to connect the dots. Today we ask for the incorporation of a body to cause the regulation on a mandatory basis to cause all members who intend to practice as urban and regional planners that they must mandatorily constitute themselves as members of a council which we seek to establish under Part 2 of this particular bill in Clause 4, and also that that council be responsible for the licensing of urban and regional planners, as we have in Part 3 of this bill in clauses 15 to 28 included. That we ask for there to be established a register for urban and regional planners, as we have in Part 4 of the bill, which is clauses 29 to 33. As we get to a committee of the council to consider exercising disciplinary proceedings if necessary against urban and regional planners, as we have in Part 5. What those disciplinary proceedings ought to be, as we have in Part 6, clauses 50 to 53, and then what offenses and penalties exist. Now, what is this all about? This is all squarely seated, Madam President, in Parts 5 and Part 7 of the Act number 10 of 2014, the Planning and Facilitation of Development Act, is a law which was long in the making. That law saw us go through many iterations of cycle of planning. Legislation was contemplated, a new national planning system. Since 1988, there was a comprehensive reform exercise for the Town and Country Planning Act. That Town and Country Planning Act, in fact, Madam President, is an English law of 1925 and then 1947. Our planning laws are as old as that. The British 1947 law. So our country in 1988 set about considering reforms. In 1995, we had the IDB funding reforms in the Agricultural Reform Program. In 1996, we had the National Physical Planning Commission, the Planning and Development of Land Bill 1998. After 1998, we had the Planning and Facilitation, the Planning and Development of Land Bill 1999, the Planning and Development of Land Bill 2000, the Planning and Development of Land Bill 2000, the Planning and Development of Land Number 2 Bill 2000, the Planning and Development of Land Bill 2000, all of which never saw the light of day. We then had the pickup of that last bill, the Planning and Development of Land Bill 2000, in 2011. We established a Joint Select Committee. I, in fact, served as an opposition senator on that Joint Select Committee, and we birthed the Planning and Facilitation Development Act, number 10 of 2014, as I welcome you, Mr. Vice President. That was, in fact, a special select committee that sat on that particular point. Now, this Planning and Facilitation Development Act, which is relevant to this bill, does some very important things. It creates a preparation and approval of a national and subnational development planning aspect. It allows for planning and development approvals for development applications. It allows for the establishment of a national planning authority that will collaborate with the EMA. It allows for the decentralization of certain decisions-making powers with respect to local government issues, including planning. Let me repeat that. It allows for the decentralization. Let me stick a pin on that word. Let me therefore jump immediately to, Mr. Vice President, what the Planning and Facilitation Development Act anchors this bill in. We must jump to Part 5 of the Planning and Facilitation Development Act, number 10 of 2014. Part 5, beginning with Clause 29, allows for development control. And permit me to cite this, Mr. Vice President. When we look at Part 5, it's called Development Control. In this act, they define development, and then they go through all of the processes as to what you need to have development control done by. It is a process of application, to whom you make the application, and very importantly, we divide out complex planning permission from simple planning permission. Complex planning permission is done by way of the higher body at the ministry level, and simple planning permission is done at the local government level. And then, Mr. Vice President, we jump to Part 7. Part 7 is the listing of professionals. It begins at Section 73 of that particular point. And Part 7, we refer to professional governing bodies, and we refer to the professional governing bodies for architects, engineers, land surveyors, and hear this, urban and regional planners established under the Urban and Regional Planning Profession Act. In other words, in 2013 and 2014, in this Act of Parliament, in Section 73, we referred to a professional organization that was not yet created. This bill today is to create that professional governing body. Why do you want the urban and regional planners? You want the urban and regional planners because we allow them the ability to have a delegated function and responsibility. The Planning and Facilitation Development Act number 10 of 2014 says we will entrust planning, delivery of certain matters to certain professionals who are listed with the planning authorities. Architects, engineers, land surveyors, and urban planners. Why? In the decentralization of the structure, we say that these professionals, because they are going to have professional indemnity insurance, because they're going to be listed, because they're going to be regulated, because they will have to have a bond for the performance of their fiduciary responsibilities, they will be allowed the latitude to engage in delegated planning approvals. In other words, the Planning and Facilitation Development Act must have listed professionals who will have charge of managing development approvals on a faster rate. It creates a solution to bottlenecking. It creates a solution to the ease of doing business. So that is to seat this bill in the law, because if you just consider this bill, it won't make sense if you don't give a context of the law. The Urban and Regional Planning Profession bill before us now, originally in 2019 when we drafted this bill, we drafted it as a 3/5 majority bill, because at that point, the law was not as settled as it is now. Coming out of the Supreme Court of Barbados, in the Court of Appeal, in the case of Norman MacDonald Nurse versus the Attorney General, the jurisprudence is now settled that mandatory membership in a professional body is not a breach of your constitutional rights, provided that the mandatory membership is vested in a public body for a public purpose in the public interest. Public body, public purpose in the public interest. And the example of the constitutionality of that approach is found in the following laws: the architects' professional body law, the engineers, the land surveyors, dentists, doctors. All of those professional bodies require mandatory membership, and all of them were passed with simple majority in Trinidad and Tobago. The only professional association that has been passed with a 3/5 majority is the legal profession. Because in 1986, when that law was being considered, the Legal Profession Act operated then with the jurisprudence at that date in 1986 to say that there could have been an infringement of rights. The law is now settled that there is no infringement of rights in that purpose, and therefore, in the House of Representatives, we removed the 3/5 majority clause. I want to remind honorable members that in this Parliament, this Senate just passed the Real Estate Agents Bill. That has been passed in both houses of Parliament, and we passed that with a simple majority because of the public body with a public interest exercising a public function had a mandatory membership of members, and all members of the Senate were happy with that approach. I raise that because we just had a whole amount of time spent on passing law involving the removal of a 3/5 majority. Even though that's not before us now, Mr. Vice President, I'll say I have no discomfort in there being an agreement to disagree. We have passed many a law before without unanimity. We passed the Children's Act in 2012 with not a single independent senator supporting the bill. Not a single independent senator supporting the bill. Only the PNM bench in opposition and the government passed that law. That law today is one of the most robust laws in our country because you see, you can agree to disagree. You can't have a weak spine in this game, Mr. Vice President, when you're fighting for rights, Mr. Vice President. And the rights that we're fighting for here are equally important as rights that we fight for elsewhere when we're protecting people, be it under interception of communications, for example, when you're protecting the interest under the public planning system, under the Planning and Facilitation Development Act, or under the Urban and Regional Planning Association. You have got to make sure that you have the courage to pass law. So let's look to the bill. The bill is divided into several parts, and we have 8 schedules. In the parts that we look at, we have the preliminary sections, interpretation, commencement. In the part 2, we're treating with the Trinidad and Tobago Council for Urban and Regional Planners, and it is here that we establish a council. We cause the composition of the council. Clause 6 is very important because we deal with the functions of the council. It is Clause 6 that feeds what the public interest is. Clause 4, in establishing the council, we create a public body, that is the council, to exercise public functions, that's Clause 6, in the public interest, which is the rest of the bill. What is the public interest? It is to be found in the provisions, Clauses 50 to 53, disciplinary proceedings, Part 6, and offenses and penalties in Part 7. So what does Clause 4 provide for us? Clause 4 provides for us that we're establishing a body corporate to be known as the Trinidad and Tobago Council for Urban and Regional Planners. What time is full time, Mr. Vice President?
3:08.
Much obliged. We establish that public body, a statutory authority. We say that the council shall be comprised of 7 members, but we bifurcate it. We allow members, being an attorney at law with experience in urban and regional, 2 state planners, because state planners come from the public service aspect. We allow for someone to represent the public interest. And of course, I recognize that the minister appoints these people. But in subsection B, the 3 persons nominated by the Trinidad and Tobago Society of Planners is what is relevant in the balancing of interests. These 3 people come from a separate body other than the executive of Trinidad and Tobago. Mr. Vice President, we go on to suggest what the quorum is, who's treasurer, who's secretary. Clause 6, which is important, the functions of the council. And here is the public interest. Keep the administration of this act under review. Register and license persons to practice urban and regional planning. Monitor and adhere to the code of ethics. Institute disciplinary proceedings. Review periodically application fees. Suspend or revoke the registration or license of an urban and regional planner. Remove or place the name on the register. Collect such fees as may be prescribed. Perform such functions as may be required. Is the collection of the fee something to be viewed to be an infringement of your Section 4 and 5 rights? No, it's not. In the Trinidad Cane Farmers Association, and umpteen laws that have been tested in particular cess stations, etc., in Trinidad and Tobago, I can tell you that this has been well managed, that none of these things concern rights of property, and our laws are very clear on that. Mr. Vice President, we allow for the tenure to be 3 years with capable of extension. We allow for members to vacate on the usual terms and conditions in Clause 8 on death, expiry of term, resignation, or if removed from office. We allow for the removal from office for the usual factors in legislation. Unable to function because of physical and mental illness, absent without leave, etc., etc., guilty of misbehavior in office, bankruptcy, or disqualification or suspension. We allow for the council to pay its members remuneration, again, standard terms and conditions. The seal of the council is at Clause 10, meetings defined at Clause 11, the quorum is set out at Clause 12, being 4, 2 from those appointed by the minister and 2 from those from the Trinidad and Tobago Society for Planners. We allow for the voting to be by way of majority. Part 3 is relevant, beginning at Clause 15, where we look at the licensing of urban and regional planners. And we say here, no person shall practice as an urban and regional planner in Trinidad and Tobago unless name is on the register and you hold a valid license. 16, 18, and 19. Why? It is a requirement that if these people are going to have the privilege and powers under the Planning and Facilitation Development Act number 10 of 2014, if they're going to have the powers under that act, they must be licensed in the public interest and for the public good. Mr. Vice President, we allow for several types of applicants for licensing. We allow for provisional, temporary, and effectively permanent licensing. We allow for these licensing to be based upon your qualifications. Are you with a Bachelor of Sciences degree? Are you with a master's degree? How many years experience do you have? In the case of a BSc, you're looking for 3 years experience being the line that takes you into the non-provisional aspect. In the case of masters, more than 2 years practical experience. So we treat with professional licenses, provisional licenses, and we make sure that we treat with licensing in the context of citizens of this country, residents of this country, and very importantly, under our provisions in the CARICOM single market for the qualifying Caribbean community states. Because we as a government have signed on to the Caribbean single economic structures, a single market led by prime ministers in this region, importantly by Prime Minister Dr. Rowley. Mr. Vice President, we obviously allow for urban and regional planners to demand and recover their remuneration in Clause 22. But we say that they are only entitled to the reasonableness of that, and that you cannot be practicing as an urban and regional planner, i.e. a quack, or a bush planner if you want to call it in Trinidadian parlance, and you cannot levy fees. It's an offense to charge people if you are not licensed to engage in this industry. Mr. Vice President, we obviously provide for the revocation of license, and that's very important at Clause 25, for the grounds of professional misconduct, conviction of an offense under the usual terms and conditions. We allow for the revocation of a license from someone in that capacity then having the right to reapply for a license. And therefore that preserves due process, and you see that at Clause 26. Very importantly, we've allowed for the right of appeal. You must preserve the right of appeal and the due process provisions, and that is at Clause 27. A person may appeal to the Environmental Commission on any decision of the Council, including a decision to refuse the renewal of his license, a revocation of his license, a suspension of his license, a refusal of his reapplication, and that the Environmental Commission, on hearing the appeal, may make such orders as it deems just. Mr. Vice President, obviously, the rules of court provisions at the Environmental Commission are applied. Now, why did we not just let this be in the domain of the regular High Court applications? Why did we use the Environmental Commission? We used the Environmental Commission on this occasion because the pool of urban and regional planners is so very small. And therefore, that Environmental Commission as a rule for route of access was most appropriate, and in this instance, not the High Court, because the sheer volume is so low in these particular circumstances. Part 4, treats with the Register for Urban and Regional Planners. And this is important because the register is there for transparency, and the register is there to ensure that the public and the public sector knows who's licensed. Because if you're going to have a devolving of authority to conduct development planning under the Planning and Facilitation Development Act, you need to know if the person is licensed and currently licensed, most importantly. Mr. Vice President, we set up under Part 5 the committees of the Council. Very important, a recognition committee, and very important as well, a disciplinary committee. And the recognition committee does the scrutinizing and examining of applications, etc., for licenses. They liaise with the Accreditation Council. They look at the assessing and keeping under review of academic qualifications, this whole concept that many professions are wrestling with of continuing professional education and assessment. And the Recognition Committee, we've set out how it is comprised, what they do under Clause 36. We allow for resignation of those members from the committee. We then get, if I could jump past the other provisions of 38, 39, 40, 41, which deal with the recognition committees, let's get down to the disciplinary committee at Clause 43. The disciplinary committee carries the constitutionality of mandatory licensing into effect. Why? Somebody has to, in the public interest, via a public body, protect the public. And Clause 43 in the disciplinary committee, the conduct of disciplinary proceedings on the receipt of a complaint, the inquiry into matters referred, and the making of recommendations to the council is a critical function to make sure that professional misconduct does not find its way in a system where the Planning and Facilitation Development Act trusts the urban and regional planner to be the kind of professional worthy of carrying out development planning in this country in a devolved situation. Mr. Vice President, we have an entire
Attorney General,
section.
you have 5 more minutes.
Much obliged, sir. We have an entire section on Part 6, which deals with disciplinary proceedings. Again, it is important that there is certainty of law, beginning in Clause 50, straight through to the rules in Clause 51, the reports in Clause 52, the consideration of the reports by the Council in Clause 53. And then we get to what is the certainty of offenses. Part 7 treats with offenses and penalties. A person who practices without a valid license, who demands or receives a fee, gratuity, or remuneration, who makes use of the name urban and regional planner, who represents by way of advertisement that he's qualified, commits an offense if you're not licensed. Liable on summary conviction to a fine of $15,000 and imprisonment for 2 years. Obtaining a license fraudulently, making a fraudulent entry on the register, practicing while suspended, professional misconduct. These are all matters the subject of offenses. This is so because of the enormity of responsibility that is being provided to urban and regional planners. You cannot leave your system of development to somebody who is unlicensed. Why? What does this mean for citizens? When we look at flooding in this country, when we look at ad hoc development in this country, and we wonder where it comes from, a lot of it comes because of unregulated and unsupervised planning, where the water that runs off of our hills are not caught and managed into our rivers. We can avoid catastrophic events by better planning of our environment. The Planning and Facilitation of Development law, tied into the local government law, tied into the urban and regional planners, tied into the engineering, architects, land surveyors, all of these bodies working together bring us to a better Trinidad and Tobago. The lifeblood of local government reform requires money. Money must be dealt with by an effective revenue authority. Money must be dealt with by your property tax, eventually in a reasonable and low fashion, coming to allow the local communities the ability to spend their own money so that schools may be bettered, roads may be bettered, drains may be bettered, pavements may be bettered for both able or differently abled persons. And therefore, Mr. Vice President, we have to function in a society where we make provision for regular activity. The matrix of approach from the Attorney General's office has been that every single law is connected to the other. Little did we know when we passed the amendments to the SSA Act in 2015, where we had one independent support that bill. Thank the Lord that particular law has stood the test of time today. That law has allowed Trinidad and Tobago a fighting chance. Today, we look at this law needing a fighting chance. This law is relevant to a better Trinidad and Tobago. This law is relevant to completing the management of resources. This law is what can follow the money. This law is how you protect against white-collar crime. And therefore, Mr. Vice President, if you know who has the authority to plan and you hold them accountable, you make them have professional indemnity insurance, you make them have a bond, you make them subject to offenses if they practice outside of the law, you're able to know who, with stolen money, was building a property without planning permission outside the system. You see how the pieces connect, Mr. Vice President? It's all one matrix. Mr. Vice President, I don't think this is too complicated a bill for us to consider today. I look forward to the contributions of honorable members, and I beg to move.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled an Act to establish a Council for Urban and Regional Planners and to provide for the regulation of the urban and regional planning profession and other matters incidental thereto be now read a second time. Senator Mark.
Thank you. Thank you very much, Mr. Vice President, for allowing me another opportunity to speak and to address a bill dealing with the establishment of a Council for Urban and Regional Planners and the regulation of the entire profession. Mr. Vice President, this bill has had various incarnations. I remember this bill being discussed and debated in 2013, in 2014, and of course, the last incarnation would have been in the House of Representatives. Mr. Vice President, I would like to say from the outset that when this bill was first introduced in the other place, as the Attorney General said, it had a constitutional majority. But in his normal style, the Attorney General gutted, removed, which is now becoming a habit of this Attorney General, the special constitutional majority. And he used the Supreme Court of Barbados decision in the McDonnell Nurse matter and the Law Association to indicate that it was okay for persons to become compulsorily members of an association, and therefore no rights, were being infringed. But if you look at this Honorable Attorney General's contribution when he was a member of the opposition in 2014, and this bill was brought, this bill in 2014 had a certificate of 3/5. And the then Faris Alwari, Senator Faris Alwari, supported the bill, but he did it with some provisos. And when I read this contribution to this bill, I thought Senator Faris Alwari was cloning me. Because everything that I stood for, and I would have argued, was argued by the Honorable Senator. And Mr. Vice President, what has changed? The only thing that has changed is that there has been a shift in where we sit. He's now in government, I am in opposition. Temporarily. This bill, Mr. Vice President, I would insist, requires a special constitutional majority. And I'll tell you why I am insisting very early that this bill violates sections 4 and 5 of the Constitution. Mr. Vice President, like the former Senator Faris Alwari, I would argue that it interferes with property rights. It interferes with the due process rights. And it also interferes with what is called equality of treatment rights. And in this context, I would like to adopt fully the position adopted by the then Senator Faris Alwari, indicating that this bill was a constitutional majority was needed, and what was even more important is that the then senator indicated the various rights of the people that were being infringed. Mr. Vice President, I want to ask a question. The Barbados Supreme Court, whilst it has made a decision, is that decision binding on Trinidad and Tobago? So the Attorney General tells us that Nurse versus the Law Association, the Supreme Court of Barbados has ruled that there is nothing wrong, Mr. Vice President, in you being asked compulsorily to be a member of that association in Barbados. And because of that, the Attorney General removed the certificate and says, because Barbados Supreme Court determined that, we must then follow. Our highest court of appeal is the Privy Council. And we have a judgment here from TICFA. Mr. Vice President, that makes it and tells you it is illegal and unconstitutional to force somebody to be a member of another association. So this is why I'm arguing that we have to be very careful when we adopt wholesale decisions when they could guide us, but I do not believe they can bind us. There's a difference between guiding you and binding you. And therefore, the Attorney General is totally wrong to come and tell us, because the Supreme Court of Barbados said X, we must jump to that beat. The highest court of appeal of Barbados is not the Privy Council, you know. It's the Caribbean Court of Justice. So we have to be very careful, Mr. Vice President, when these things are being advanced to us. And I want to say, as I make my contribution to this bill, I say from here on, I adopt all the positions put forward by the Attorney General as it relates to the bill of 2014, which is what we are dealing with today. And I'm going to propose all his amendments that he proposed then to change the bill. And we will see where the Attorney General stands today. You know, Mr. Vice President, the Attorney General in that bill, there was no provision for a negative or an affirmative resolution. You know, the Attorney General insisted that there must be a provision in the law that was being debated in 2014 to have, he talked about affirmative, but he didn't go with the affirmative. He said this law must have a negative resolution.
Standing Order 46.1, most respectfully. 46.1, sir.
No, I am relating this bill to his contribution, and I'm adopting wholesale.
Senator Mark, please allow me to take a seat. Thank you. Please allow me to rule. Okay? All right. Attorney General, Senator Mark, I would allow you to continue, but just be very careful. Continue.
Yeah. So, Mr. Vice President, I'm saying when I go to clause, let me go to the clause itself so that I will be guided by your ruling. I am going to clause 60 of the bill, and in clause 60 of the bill, Mr. Vice President, there is subsection 3 that deals with regulations and mere consultation with the council. I am arguing like the Attorney General did as Senator Alwari in 2014, and he did that, Mr. Vice President. The date that that contribution was made was the 25th of November, 2014. And I am also insisting that we make the necessary changes to ensure that this bill is subject to an affirmative resolution. I will be proposing several amendments to this piece of legislation, Mr. Vice President. Mr. Vice President, the first matter that jumped out at me, when I read clause 5 of the bill, Mr. Vice President, I really thought this was a PNM party group. I do not know why they are calling this council an urban council. This is not an urban council. This is a PNM council. That is what it is. Mr. Vice President, I have with me all the legislation governing, and I wouldn't burden you today because I wouldn't have the time. But I can tell you, Mr. Vice President, that when you look at the Medical Board Act, when you look at the Legal Profession Act, of which the Attorney General is a member, when you look at the Engineering Profession Act, as examples, Mr. Vice President, you know what you see? You see independence. These bodies appoint their own personnel to the board, their peers. I haven't seen no minister, no politician appointing members to the Council of the Law Association. I haven't seen, Mr. Vice President, in the engineering profession, any minister appointing engineers to their council or their board. When I look at the medical profession, I am not seeing that. When you go to the architects, you're not seeing that, Mr. Vice President. When you go to the pharmacy board, when you go to the dental profession, we are not seeing politicians, be it UNC or be it PNM, appointing professionals. But, Mr. Vice President, in this bill that we are debating, you go to clause 5 of this bill, Mr. Vice President, and tell me what you see. You know what you see, Mr. Vice President? In clause 5, they tell you how many persons would comprise the council. 7 persons, Mr. Vice President. Out of those 7 persons, the minister, in this instance, a PNM minister, is appointing. This is a council of regional and urban planners. They are professionals. And you have a politician appointing 4. So here what's going on here, Mr. Vice President. Not an urban planner. The minister appoints an attorney at law with 10 years of with experience in matters relating to urban and regional planning. So you appoint an attorney with experience in planning. Then you say you're appointing 2 state planners who are professional members of the TTSP. But you are appointing them. And then you're appointing 1 person representing the TTSP, which is the Trinidad and Tobago Society of Planners. And then, Mr. Vice President, they tell the TTSP, you appoint 3. So there are 7 members. 4 are appointed by the government through the Minister of Planning and Development. And 3 are appointed by the Trinidad and Tobago Society of Planners. Could you imagine that? Mr. Vice President, you are a professional and you have a politician appointing you to your profession? It does not exist in all the acts that I've read. Pharmacy Board Act, the Dental Profession Act, the Medical Board Act, the Legal Profession Act. They appoint them. In other words, lawyers are appointed to the council by lawyers, not by politicians. So, Mr. Vice President, something is wrong with this. It doesn't end there. The Minister of Planning and Development or any other minister, Mr. Vice President, goes and appoints the chairman. So the minister is appointing the chairman of that council. So there's a party group that cannot be a professional body. And I want to serve notice on this government that we will not be supporting this. We will be proposing amendments to give this body the independence that it deserves. So I want to make that point. Mr. Vice President, not only is the minister appointing the chairman, the minister is also appointing the vice chairman in accordance with the act here in clause 5, Mr. Vice President. As if that isn't enough, Mr. Vice President, the minister can remove you, has the power to remove you. So the minister could appoint, the minister could then disappoint, and then the minister will appoint the chairman and the vice chairman. That is madness in 2020. This cannot be right. How can this be real? I'm sorry that the Attorney General had to run when I so leave the Senate for whatever reason. But, Mr. Vice President, I find it amazing that we can be debating a bill today in which a politician has complete control over the council. Reprehensible, unacceptable, indefensible, inexcusable, cannot be accepted. So, Mr. Vice President, this is the first matter that came to me, Mr. Vice President. I found it very strange. The minister has too much power. And, Mr. Vice President, the minister also has power to appoint alternates. Alternates. to a professional body. So the minister is not satisfied with appointing the majority of members to this council, but the minister is also going to be appointing alternates. So if you happen as a member not to be present at a meeting, the minister will have the power to appoint you as an alternate. That is what I'm saying, Mr. Vice President, with the greatest of respects. This is not a professional council. This is not an independent council. This is a PNM party group that they are appointing as under the rubric of a professional organization. How can we in 2020, Mr. Vice President, identify with that kind of backwardness? This is retrogression. We cannot support this, Mr. Vice President. And therefore, I want to let you know that we intend, Mr. Vice President, to put forward a number of amendments for the consideration of this Honorable Senate, Mr. Vice President. Mr. Vice President, there is, when you go to, I saw something also that I couldn't understand. If you go to clause 15 of the bill, Mr. Vice President, you will see where, I don't know why this is necessary, because it is a given. We do not live in a Spanish-speaking country, and we do not speak Spanish as our first language. But I saw in 15 subsection 2, where we are being told that an applicant for a license shall be proficient in the English language. I don't know what was the relevance of that, Mr. Vice President. But let me go to clause 15(3) C, Mr. Vice President. I'm seeing here, and these are people who can be given temporary licenses. Some people get permanent licenses, some will get provisional licenses, some will get also, Mr. Vice President, temporary licenses. Mr. Vice President, as I'm on this point, I'm a bit concerned that there will be a collision as it relates to this legislation. Mr. Vice President, do you know that there is an act of Parliament incorporating the Trinidad and Tobago Society of Planners? Do you know this? Mr. Vice President, do you know in that act governing, and Mr. President, that came into being in 1975, before you were born. Because I know you're a young man. But in 1975, Mr. Vice President, this came into being, right? And some of the provisions, Mr. Vice President, that we have in the legislation that we are now debating are also contained in that act incorporating the Trinidad and Tobago Society of Planners. They have a disciplinary committee. They have a recognition committee. They have a board of directors. We have a council. They have a board. They have a disciplinary committee here, which I'll talk about. They also have that there. They have a recognition committee here. It is also there. Mr. Vice President, what is going on? What is going on? I don't know. We are talking about a code of ethics for this body. They also have a code of ethics for their professionals. The same society of planners, both urban and rural, they already have these bodies, these institutions. So, Mr. Vice President, I don't know what to make of this that is before us. Then I saw here, Mr. Vice President, where in section 15, subclause 3C, it says that a certificate of good standing from the TTSP, which is the Trinidad and Tobago Society of Planners, or in case of an applicant for a temporary license under Section 19. And I would have thought that if you want to get a certificate of good standing in order to submit to a body to determine if you'll get a temporary or a provisional license, I would have thought, Mr. Vice President, that a certificate of good character from the police service might have been more appropriate. But this is not the case. Now, we are also seeing in clause 19, Mr. Vice President, subclause 4, it states that if a temporary license issued under subsection 1 is deemed invalid, where it is discovered subsequently that the application contained misrepresentation of documents or falsification of any document under this clause, then they are saying, Mr. Vice President, that that would not be permissible, and therefore they would deny that issuance of the temporary license.
Senator, you have 5 more minutes.
But, Mr. Vice President, you know what? This is not applicable across the board to professional and provisional licenses, which is something that we ought to address. I have seen some inconsistencies in the various schedules in terms of the language. They are speaking in the past tense. And I think that schedule forms 1, 2, and 3 of the 5th schedule, we will need to revisit, Mr. Vice President, because the language certainly is not in keeping with what is required in this piece of legislation. Mr. Vice President, let's go to the committees, and we need to determine these committees, and they are found, Mr. Vice President, in clause 34 of the legislation. And in clause 34 of the legislation, it states that the council shall appoint a recognition committee and a disciplinary committee, Mr. Vice President. It goes on to say that these committees would comprise of 5 members, but nowhere in the legislation does it refer to how these members of this committee would be remunerated for their services. So that is an area, Mr. Vice President, we need to pay attention to. Then they talk about in clause 36.3, that the members should have a term not exceeding 3 years. We may need to look at that. In clause 53.2, it talks about revocation of a license or removal of the person's name on the register. And Mr. Vice President, I come to my favorite, and that has to do with regulations. I cannot see in 2020 where you can bring a bill and simply say, Mr. Vice President, in clause 60, that you are going to develop regulations simply in consultation with the council. So, Mr. Vice President, hear what this is saying. The minister may, after consultation with the council, make regulations. Himself making regulation for himself. The government is appointing, Mr. Vice President, the majority of members to the council. The government is consulting with its council to make regulations. And the government is not bringing those regulations to the Parliament for affirmative resolution. It is staying within the Council. Mr. Vice President, something is wrong with this bill. We intend to fix it. We intend to submit a number of amendments to strengthen the legislation. And we will do so at the appropriate time, with your leave, so that we can strengthen this legislation and get from the Attorney General and the government how are they going to treat with this parallel organization. You have the council that has been established, and you have something called the Trinidad and Tobago Society of Planners. How are these two bodies going to work together in this environment? These are matters that we need to have cleared up and clarified from the government, and we hope that at the committee stage, these matters would be addressed. But for the moment, Mr. Vice President, in closing, I want to compliment the Attorney General for being so forthright in his contribution in 2014, and I will be adopting all of his amendments that he would have proposed in 2014 during the committee stage. I thank the Attorney General for his vision and his wisdom in this matter. I thank you very much, Mr. Vice President.
Senator Thompson-Aye.
Thank you, Mr. Vice President. The first time I heard about planning, town planners, I was a young girl, a young woman, I would say, and a young teacher. And there was a teacher I looked up to. She became my very good friend. And she used to talk to me about an injustice, as she saw it, that was done by Town and Country. And because I admired her, you know, and she felt so passionately about the subject, of course, I believed that she knew what she was talking about. So her peeve became my peeve. So she had the idea that town planners were wicked people. Why? Why did she give me that impression? Because she was very close and was a protege of Beryl McBurney. And Beryl McBurney had a long history with Tongue and Country and the Little Carib Theater. So my impression was that these people didn't treat Beryl right, and because she was very close to my dear friend Anna Chiang, I adopted Anna's view. Her righteous anger for Beryl became my righteous anger. Anna was very much, as I said, involved in the arts. She used to dance, and we used to be together preparing the children for Arts Festival. I was doing the drama and the prose and verse, and she was doing the dance. So we would meet Beryl from time to time, and I would hear that story over and over again. Later on, I would hear stories of people having to pay Tongue and Country to get them to pass a plan, or as the Calypsonian would say, run something. And what amazed me is that whenever I heard these stories, there was just an air of resignation. There was no lack of protest. It was like par for the course. But I couldn't help wondering, what kind of society do we live in that would agree that these things were normal? So again, I began to think that planners have an eye to the main chance, and they should be subject to what we have now, the explain your wealth provisions. But I must say there are some good, honest, helpful, competent people that I have met who belong to that profession. So today I come to talk about a bill to regulate this profession. The bill is to establish the Council for Urban and Regional Planners and provide for regulations for urban and regional planning profession and other matters incidental thereto. And there is a code of ethics which governs urban planners and speaks to categories of membership. And I want to look at a code of ethics that came from the South African Council of Planners. That's their policy document. When I saw the document put out by the Senate staff, the Bill Essentials, and I saw they looked at Zambia and South Africa, I was a little concerned. I thought maybe that they had intercepted my computer because I too had looked at those jurisdictions. Now, that South African Council of Planners Code of Ethics is a policy document which guides members, and it confesses in the document that it has drawn from the experiences of the Australian, the Canadian, the Americans, and British, and their own project management institute. And it says that the principles of the code is derived from the general values of society and from the planning profession's special responsibility to serve the public interest. So this code is a measure of the attainment of societal values in pursuit of the public interest goal, and a measure of good and bad behavior, a measure of our commitment to the planning profession, and a measure of accountability. So it fits in very well with our own policy document. And in fact, when we look at our code of ethics, our 6th schedule, you see that there is a parallel, because it talks about the urban and regional planners having public and private practice duties to the public, to serve the public interest. So in fact, that is what we expect, that the urban and regional planners would serve the public interest in a manner which upholds the integrity of the profession within the laws of Trinidad and Tobago. That's an important word, the integrity of the profession, because we're looking to see whether, in fact, these are reputable people performing functions in our interest, because we're all involved in this. And we expect to uphold the reputation of urban and regional planning, and they would conduct themselves in accordance with the highest standards of professional practice and integrity, and assist with the advancing the competency of the persons who are qualified or training to become urban and regional planners. Now, when we look at the Code of Ethics of South Africa, which I've mentioned before, it defines fairness, which we don't find in our legislation. And it says fairness, if I may, Madam President, our duty to make decisions and act impartially and objectively. Our conduct must be free from competing self-interest, prejudice, and favoritism. We should make decisions solely on merit and in accordance with our professional and elected obligations. And that is, in fact, mirrored in our Code of Ethics as well, because it says in Part 5, it talks about self-responsibility. And it states at Clause 18A, an urban and regional planner shall respect the rights of others, and in particular shall not improperly discriminate against any person in the practice of his profession, planning decisions based on principle of fairness, repose confidence in the profession and in private and commercial interests. Now, many times we do not understand why you don't get planning permission. It isn't always clear, and why we don't. Why we do, and sometimes why we don't. I remember a time when it was said that you could not have a building that was a two-story building in a particular development. Twin City, for example. So that people who applied could not go up, as we call it. But then we found in later years that people were building two-story buildings next to flat houses, and one wonders what was going on. There was nothing to really guide you, but I understand now that there is a policy document, but is it available, readily available, so that now you can apply? At times you're told, and there's been actual cases, that you cannot have commercial business operating in a particular area, and you can only, because it is only for residential. But right next to you, there is a commercial building, and further up the road, there is another commercial building. And therefore, that raises the issue of, is there fairness? Is there fairness? And sometimes people would try to see what they can do to assist with overcoming their difficulty, but then everybody can't fight for City Hall. Sometimes the resources are just not there. So you, just like the naughty boy in Junkies, you just stand in your shoes and you wonder, is Trinidad and Tobago a real place? So we hope that this new legislation that we are putting on the books, that in fact people will abide by the code of ethics, and it will be seen that everyone is acting fairly. Now, when we look at Clause 3, which is the interpretation section of the bill, we see something called a certificate of title, of good standing, sorry. And that certificate of good standing is a statement issued by the TTSP, which is the Trinidad and Tobago Society of Planners, which certifies that a person has, inter alia, completed within the past year a number of hours of continuing professional development. Now, continuing education is a subject very close to my heart. I always used to emphasize to the law students, you must keep abreast, you must go to conferences and symposia, you must read, you must always keep learning. I'm happy to see that Trinidad and Tobago Law Association is now doing some continuing legal education, but it is not mandatory, it is voluntary, unlike the Jamaica Law Council, which for some years now dragged into the continuing education into their way of expectations for the attorneys, kicking and screaming. But we, in Jamaica, they have it, and we hope that at some point, Trinidad and Tobago will have it mandatory for lawyers as other professions. And there is precedent for including that requirement in the legislation, because if we look at Zambia, which is one of the pieces of legislation I mentioned before, that has been looked at as a model for our present bill that we are discussing, you will see in Section 9 of their Urban and Regional Planners Act that a function of the council is to promote continuing professional development among planners. And when you look at our code of ethics, it says to seek to maintain professional competence throughout his professional life. That is something that is required. So who should do it? It should be a function of the council. When you look at Clause 3 again, continuing the definition section, there is a definition in our law, our proposed law, of urban and regional planner. But there is no definition of who simply is a planner. If you look at the Bill Essentials, you will see that the models that our framers of this bill looked at is also, you see that they also have it in their legislation. In the Zambia legislation, planner is defined as a person with special knowledge of urban designing the environmental, social, economic, and political issues with spatial approach to problem solving acquired through planning, education, experience. Now, why would I recommend that we include such a definition in our interpretation section? I say so because if you define who is a planner before you go on to define specialist planners, then it will assist the Accreditation Council, which has the responsibility for assessing and pronouncing on the accredited status of an institution providing academic training, so it would be useful for them. When I look at Clause 6, functions of the Council, I would like to add another function. And I look again at the Zambia legislation, which says in Section 9, to make recommendations affecting or relating to the planning profession to the general meeting. It is important for those people who manage the council to keep abreast of changes, innovations in the profession worldwide, so they can in fact seek to achieve improvements in the law and practice. And I want to tie this in with our the World Sustainable Development Goals. And Goal 11 talks about having make cities and human settlements inclusive, safe, resilient, and sustainable. By 2030, ensure access for all to adequate, safe, and affordable housing and basic services and upgrade slums. When we look at Goal 11.3, by 2030, to enhance the inclusive and sustainable urbanization and capacity for participatory, integrated, and sustainable human settlement planning and management in all countries. Now, Barbados, in their brief, the introduction to their planning and development legislation, also looked at the Sustainable Development Goals. In fact, that is one of the headings. Decisions should be guided by the principles of sustainable development, ensuring long-term environmental, economic, and community health and well-being. So that it is important that we not only talk about sustainable development goals, but at every opportunity, try to bring the goals into whatever we are doing to improve the well-being of our citizens. When we look at the Code of Ethics, again, it's tied into the whole idea of improvement of what we do with our planning. It talks about state planners in their practice to have regard to the totality of land use and adjacent seabed, ensure rational and sustainable utilization of land and related natural resources, consider the integrated development of settlements and supporting networks which promote human well-being, environmental harmony, and aesthetics. When we look at some of the buildings that have been approved, we wonder really if there's any question of aesthetics there. There's a particular Institute of Higher Learning that every time I see the buildings that they have, really, it makes me get very upset because it's an extremely ugly building, and, but it's cropping up over wherever they decide to have a branch. Now, research has shown how lack of urban management has had negative consequences. The poor, the people who cannot afford to buy land, they go and, in fact, they put down their houses anywhere. And we know the consequences. We know the flooding. We know the natural disasters that are happening in this country. And therefore, we always have to be vigilant to ensure that things are done in a proper way, that there must be monitoring all the time. When we look at Clause 8, which deals with demitting and removal of office for members of the council, we see that it talks about death. Of course, you can't continue if you're dead. The expiration of the term, resignation and removal of office by the minister. So we have, first of all, the use of the word shall And then we have the may. And my question is, we know that in legal drafting, sometimes may is mandatory and sometimes it is not. Is it discretionary in this case? Because when we look at some of the provisions that the minister may remove, not shall, but may remove, if someone is convicted in any court of a criminal offense under this act, or which carries a penalty of imprisonment for a term of 6 or more months, someone who is guilty of misbehavior in office, someone who has been declared bankrupt in accordance with the laws of Trinidad and Tobago, someone who is disqualified or suspended otherwise at his own request from practicing his profession in Trinidad and Tobago or in any other country by an order of any competent authority. And when we put that against our code of ethics, that an urban and regional planner shall conduct himself in such a manner as not to prejudice his professional reputation, I wonder if this provision in the code is really something that can go along with a discretionary provision, which also occurs in clause 46 for members of the disciplinary committee. Do we want, as members of council, do we want as members of the disciplinary committee someone who has been convicted? I heard the Attorney General speak of a limited supply. But if we want to talk about persons with integrity, do we want someone there, especially like in a disciplinary committee, to sit in judgment of someone else if you yourself has been charged with misbehavior or has been convicted of a criminal offense? This doesn't sit well, it seems to me, for what we want. Now, when we look at the disciplinary committee, I do not see in the bill at all any limitation of time in terms of the appointment. So whereas the recognition committee, it states in clause 36, I believe, that you're there for 3 years, I do not see a similar provision for the disciplinary committee. So is it that if you're on a disciplinary committee that you sit forever and ever, amen? I would like to know. Certainly, I would recommend that a period of 3 years, which occurs in other parts in the recognition committee, should be also in for the disciplinary committee members. Now, when I look at the disciplinary committee provisions, clause 50, we see that they can make recommendations after they have been hearing complaints against a member. And I wonder why they can only make recommendations and cannot make decisions. The disciplinary committee of the Law Association certainly can make decisions and awards. And why is it that they're just hearing complaints? And when you look at the provision, it speaks about the disciplinary committee at the end of the day that they would send a copy, whatever recommendation, together with a copy of the record of the proceedings to the council. Now, I would like to recommend, and I say it would be helpful to the council in its deliberations, that the council, what should happen as well is that not only the proceedings and decisions, but actually a report of the proceedings. Because if someone has, it goes to the council, and you have to make a final decision, it is very helpful, having sat on inquiries before, it's very helpful if you can see exactly what happened in the proceedings. Because, you might have a question of a judicial review or something, so at least you have all the proceedings there that one can look at to make the decision. Now, I find that there is some limitation in the kind of decisions that can be made, and I would recommend that when you look at, again, Zambia's law, that it could be expanded to include the imposition of a fine, that an order can be made to pay restitution because someone may be harmed by the decision that has been made, and therefore, provision can be made for those persons to be compensated, and also for the payment of costs for anyone who has been prejudiced by the decision of the council. Now, I heard Senator coming before me speak about the how the council is determined, how, that the minister is the one who nominates. I find the word nominate to be a very curious one, because to me, nominate would mean to propose for election. So what do you mean by the minister nominating? Is it that the minister is, in fact, appointing? Because there is no process here for any election as far as I can see. May I inquire, Madam President, how much time I have left, if any?
4:08.
All right, thank you. So this is clause 5. The council shall comprise of the following 7 members. I'll come to that construction again. 4 persons nominated by the minister as follows: 1 attorney at law with experience in matters relating to urban and regional planning. And perhaps what we can do is have the law association propose someone, the attorney at law that we want to have on the council, instead of the minister.
Senator Thompson-Aye, you have 5 more minutes.
Thank you. But we can have the law association propose someone to be a member of that council. So if that happens, it means that we will have 3 persons nominated or proposed or appointed by the minister. Then we have 1 by the law association and 3 persons nominated by TTSP, the association, who are professional members. So that would help to have more of a balance. You have 3, 3, and 1. And of course, all members can get their final instruments from the minister or whomsoever you may choose. All in all, this is a welcome bill, and it can really make a difference to people's lives once it is, everything is done as supposed to be done. It will certainly help to inspire confidence in the populace, and once my recommendations are accepted in terms of looking at sustainable development goals and so on, certainly it would bring us more into the 21st century. But of course, I cannot leave this alone. As I close, I wish to apologize to James Ingram and say I did my best. But I guess my best wasn't good enough, because here we are back where we were before. In clause 5, I see shall comprise of. Please use shall contain, shall comprise, or include. In clause 6, use incidental to, not in, because we must find a way to finally make it right. And let me leave here happy just for one more night. Thank you.
Senator Timar.
Thank you, Madam President, for the opportunity to contribute to this bill, an act to establish a council for urban and regional planners and to provide for the regulation of urban and regional planning, profession, and other matters incidental thereto. Madam President, any attempt to increase the professionalism amongst the respective disciplines that are necessary for the planning development in general, it's a welcome move. For the more we have our professionals registered, would encourage professionalism, the genuine offer of services to clients, and at the same time it makes our professionals more marketable, not only locally, but it offers the opportunity for professions and professionals to market their services internationally. So this attempt to register our urban and regional planners is indeed a commendable move, and as the Honorable AG in piloting the bill explained, it ties in with certain key pieces of legislation, Planning and Facilitation of Development Act, and other pieces of legislation to sort of complete the framework, the matrix for urban and regional planners to fit in so that our country can benefit from that level of professionalism and also make our urban and regional planners responsible for the services that they provide, and also ensures that they are also fairly treated by those who engage their services. Madam President, I would like to go to clause 3 on page 5, which this particular clause deals with the definitions that fall within this proposed bill. And the last one, where urban and regional planning is defined, and it says means the provision of physical or spatial planning services, etc. Madam President, my main concern here, or my main disappointment here in this definition of urban and regional planning is the absence of the element or the word sustainable. Because overall, with the United Nations Sustainable Development Goals that we have subscribed to, and in fact those Sustainable Development Goals actually form the framework for Vision 2030, which has been outlined by the government. I felt that this definition should really make an attempt to include, maybe it's inherent by use of certain terms here, but specifically the use of the term sustainable whenever we speak about development in the context of planning. So I would suggest that this definition, when we speak about provision of physical or spatial planning, we should include physical, spatial, and sustainable planning. And in section B of the definition, where we refer to preparation of land use and physical development, we should also take the opportunity to include physical and sustainable development to bring home the point that one of the key features of planning and spatial and physical planning is that in the context of the Sustainable Development Goals, all planning must be sustainable. With respect to Clause 5 and Part 2 that deals with the Trinidad and Tobago Council for Urban and Regional Planners of the bill, Clause 5, Section 2, Madam President, that particular clause, which deals with appointment of alternatives, clause 5, section 4, that deal with appointment of alternatives. The clause states that the minister shall appoint in respect of each member, other than the chairman and vice chairman, an alternative. But my concern here is that in the appointment of the members of the council, as outlined in clause 5, section 1, is that the council shall comprise of 7 members, 4 persons nominated by the minister, and it states as follows: attorney of law, state planners, and 3 persons nominated by the Trinidad and Tobago Society of Planners. And what I'm saying is that the alternates for the persons nominated by the TTSP should also be done by the TTSP instead of the minister. Or maybe the TTSP should make recommendations to the minister as alternates for him to appoint such, seeing that they are the ones who are nominating their 3 persons. Madam President, I'd like to go to part 3 of the bill that deals with licensing of urban and regional planners, clause 15, section 4, in which in which a particular qualification is introduced, in that the academic qualification that is required must be from an accredited body, accredited under the Accreditation Council of Trinidad and Tobago Act. And then when we go further down to clause 16, section 3, it says that a person who is a professional member of TTSP immediately prior to the commencement of this act shall be deemed to be an urban and regional planner, and shall be entitled to have his name placed on the register. Now, Madam President, is the current criteria, I ask the question, is the current criteria for membership of the TTSP as stringent as what has been outlined in clause 15? Because particularly with regards to qualification from accredited bodies that I referred to earlier under the Accreditation Council of the Trinidad and Tobago Act. Because I accessed the website of the Trinidad and Tobago Society of Planners and tried to get some information as to what are the requirements for their professional members, because we are talking specifically about professional members here. And there's a form to be filled out, and essentially, together with the form, CV, curriculum vitae, has to be attached, as well as a listing of the work experience of the urban and regional planner. And within that form, no specific mention is made of accreditation and a process of accreditation for the qualifications of the urban and regional planner. So I'm wondering whether in the crafting of this bill and in possible consultation with the TTSP, I was wondering in terms of the criteria of the TTSP, in terms of they determining, allowing persons to become professional members, whether it's comparable with what is being proposed in this bill here, and whether a due diligence exercise was carried out to validate that the membership of the TTSP as it stands is the same as what is being proposed here in the bill. Because what it means is that all those who are members of the TTSP, once the bill is proclaimed, automatically, this clause 16.3 suggests that they automatically become registered urban and regional planners. And I am exceedingly concerned about this because for going forward, you have one set of criteria, rigid criteria for persons to be registered. And then if the criteria used for the past is not comparable, I think there is serious inequity in this provision that is being proposed here. And what I would suggest is that once this bill is proclaimed, all persons should apply for registration as urban and regional planners under this bill and not automatically qualify if they are a member of the TTSP. But all should be subjected to the process that is outlined in the bill here for registration, and not allow automatic registration based on membership on the TTSP. Madam President, I'd like to refer to Part 5, Committees of the Council, Clause 35, which speaks about the Recognition Council and the composition of the Recognition Committee, which would be a subcommittee of the proposed council. And in Clause 35, Section 2B, it mentions 4 persons, the composition of the Recognition Council being 1 member of the council, and 4 members, it says 4 persons who are professional members of the TTSP. And I'm just querying why 4 persons who are professional members of the TTSP, and why not 4 members who are registered under this act? Why the criteria should be 4 professional members of the TTSP and not 4 members who are registered under this act? Because in such a situation as what is proposed here, it seems to me that the professional membership of the TTSP takes precedence over those who are registered as urban and regional planners under this act. And I would recommend that consideration be given to changing those 4 persons, professional members of TTSP, to 4 persons who are registered under this act. The other aspect of it regards to the Recognition Committee, Madam President, is that it speaks of, in Section 4, the same Clause 35(2), the members of the Recognition Committee shall elect a chairman and a deputy chairman from among themselves. In terms of the functioning of the Recognition Committee as a subcommittee of the council, and you just only have 1 member of the council on that Recognition Committee, I was just thinking whether it would not be more professional and expedient for the functioning of the Recognition Committee
Senator Timal, you have 5 more minutes.
To not have the member of the council be the chairman of that recognition committee. So such that the reporting back to the council, the member of the council being the chairman, and for liaising with the council itself, it would be more expeditious. Madam President, the same comment that I just made about the recognition committee, I would like it to also follow in clause 44 regarding the disciplinary committee, and the 3 persons from the TTSP to be on that disciplinary committee, for those 3 persons to also be urban and regional planners registered under the Act rather than professional members of the TTSP. Madam President, the Honorable AG in piloting the bill referred to professional indemnity insurance, Madam President, but within what is proposed here in the bill, I'm not seeing any specific reference to professional indemnity insurance, and whether the urban and regional planners registered under this Act would have to, by legislation, have effect on their own or through the council or through the TTSP professional indemnity insurance. And with those few, I thank you, Madam President.
Senator.
Thank you, Madam President, for recognizing me this afternoon to contribute to a bill entitled An Act to Establish a Council for Urban and Regional Planners and to provide for the regulation of the urban and regional planning profession and other matters incidental thereto. Madam President, if you would permit me, I would like to indicate very early on that bills like these are welcome bills. They are bills that are designed to treat with lacunas that exist within our system that many persons throughout our society have to deal with on a daily basis with little or no redress to assist them. And only sometimes, unfortunately, as lawyers, when we get involved in these types of frays, we recognize how wanting our system is. That being said, I personally would like to also indicate that when coming here, I take my job and my role as a legislator very, very seriously. And I understand that we are here to do the business of the people, to improve the lives of citizens of Trinidad and Tobago. So when some of us go low, I will continue to go high. And I'm sure that all persons, not just the people of San Fernando West, but all people will appreciate that breath of fresh air in this political climate. That being said, I would want to bring what we are discussing into a proper perspective, because I think when people hear about urban planning and the discussions that were being had so far, I don't think they totally understand what this means and how it would impact our society. a lot of the times when we are conducting business, construction, making an application to the magistrate's court for a liquor license, a grocer's license, special restaurant license, we have to obtain certain approvals that come from the Town and Country Division, the regional authorities or city corporation as it may be. Some of these things entail us treating with the Ministry of Works depending upon the size of the property and the structure. And we are left wanting because we don't understand how a particular structure that could have been licensed since you know yourself growing up as a little boy, when you attempt to make a purchase or have the license converted into your name, you are met with a significant amount of changes that have to take place with respect to this structure to have the very same license that has been existing for a number of years vested in your name. And you are told by persons at these institutions that it is for the good of the environment, it is with respect to OSHA concerns and health concerns and whatnot. But then you wonder, why weren't these concerns raised or treated with during the lifetime or span that this previous business owner operated his or her establishment? And that is a huge concern that I had when reviewing the legislation and understanding the environment that we are currently existing in. And I must indicate from the get-go that the problems that plague the Town and Country Division, interwoven with what exists in the regional corporations and the Ministry of Works, some persons may not say it at all during this entire debate, but it is ramped with significant amounts of corruption and mismanagement. That you have persons setting policy within the Town and Country Division who may very well be educated and licensed accordingly. And those policies are not being followed properly through by individuals who exist within the regional corporation setting. That you may very well have an urban planner existing under such a title at the regional corporation, but with no qualifications to hold that post. You have someone called a building inspector at the regional corporation or the city corporation, but with no significant qualifications to hold that post. And so, when you as a member of society, want to purchase a property, conduct some construction, have a license vested in your name, you obtain the necessary approvals from Town and Country. You have the building inspector from regional corporation telling you something totally different. And then when you apply to the Ministry of Works now to get involved, they can only do so. And the Ministry of Works has qualified persons, engineers and planners there. But they can only do so once they are informed that there's a problem existing from the regional corporation. And these are the things that I thought, yes, we are starting with putting some structures in place, but these are the things that I thought that the legislation would fix. And it doesn't. There's no strict requirement meted out in this particular bill that would indicate that this is what's supposed to happen with respect to chain of command and chain of instructions within these three organizations. That there's also no lack of enforcement articulated within this bill for urban planners to enforce upon individuals when they run afoul or they become errant. That there should be some correlation existing, and I would like to hear it, possibly in the wrapping up from the Attorney General, between the Ministry of Works, the Ministry of Health as well too, OSHA, Town and Country, Fire, WASA, and even TNTech, with respect to enforcement, with respect to information being passed laterally amongst each other when it comes to enforcing the provisions and the stipulations that will be meted out through this particular piece of legislation. And also I would have liked to see some recommendation within the bill as it pertains to constant assessment. So I mentioned at the genesis of my contribution that there are many persons, and I have, as a lawyer representing them, persons who would like to take on licenses that would have existed, are met with a significant amount of changes that have to take place with respect to the property before they can have it vested in their name. And in most instances, they don't understand. If there was a constant level of assessment that was taking place during the lifetime of the previous license holder, then the current person who is willing to make that application to have this license, be it special restaurants, spirit retailers, grocers license, or whatever it is, vested in them, would not have to be faced with this enormous task to have the structure adapted to meet the current requirements as meted out by Town and Country. That the same requirements, the same position adopted by Town and Country with respect to ensuring that the establishment is up to code, building code, structural code, so as to ensure that persons' health concerns and whatnot are paramount. Where were those concerns 5 years ago, or 10 years ago, or 15 years ago when the building was in existence? And that is what I would have liked to see in the legislation. A need for constant assessment of structures within our country, especially as assessment for establishments that allow a lot of foot traffic, a lot of visitors and patrons at those establishments. It is non-existent. When I looked at the legislation, firstly, at page 6 of the bill, clause 5.1.3 deals with the qualifications of persons who would make up the council, or who the members of the council would be. And 5.1.3 in particular, so 5.1.1 speaks to the appointment of an attorney at law with experience in matters relating to urban and regional planning. 5.1.2 speaks to 2 state planners who are professional members in TTSP. And then 5.1.3 is simply one person representing the public interest. And there's no indication or description to any experience being attached to this individual. In what capacity would they be representing the public interest? Are we just simply going to take someone off the street? Or because it is the members of the council are appointed based upon the minister's instruction, is this person going to really be a card-carrying member of any party? So I would like to see an amendment to that where there's some degree of experience or expertise adapted to fit within this section so that it isn't some arbitrary person who's appointed to the council. Clause 5.3b as well too. So this section indicates the qualifications of the chairman, and it reads, a chairman who shall hold professional membership in TTSP and shall have at least 10 years experience in urban and regional planning, and then be a vice chairman. No indication as to the level of experience or expertise that that vice chairman may have. So the same problems that I have associated with respect to the appointment of a person representing the public interest, I would like to see some expansion on the qualifications attached to this vice chairman, who is also going to be someone extremely important in terms of the operations of the council as well too. At page 10, it deals with the application for a license to be placed upon the register of the urban and regional planning. Now, clause 15.3b, which is located on page 11, indicates that the individual should procure what is known as a certificate of fitness. So it says recommendations from 2 urban and regional planners attesting to the applicant's fitness and ability to practice urban and regional planning in Trinidad and Tobago. And then when you read on the following page, on page 12, at 4, it says, subject to subsection 3, the applicant shall submit to the council qualifications in urban and regional planning that have accredited status and are granted by institutions which are accredited under the Accreditation Council of Trinidad and Tobago Act. Now, the qualifications that are listed here are understandable. It treats with persons who may have now graduated from whatever college or institution that awards these urban planning certificates and degrees and whatnot, which I am told are really non-existent in Trinidad, and so persons would be foreign qualified. But in terms of the certificate of fitness aspect, where there's a recommendation from 2 urban regional planners attesting to the applicant's fitness and ability to practice urban and regional planning in Trinidad and Tobago, more than likely, in all cases, this may very well be a non-existent situation insofar as if you have just graduated and you have no urban and regional planning experience within Trinidad and Tobago, how are you to satisfy this requirement? Most certificates of fitness that are requested for persons to join professional organizations come from the institution that the person would have attended, indicating that the person, based upon their success at the institution, is a person fit and ready to engage in practicing in that particular field, as opposed to someone who already has that necessary or that experience associated with them. So that I think it is going to be extremely difficult for this individual who's now applying to be part to be placed upon the register to get recommendations from 2 urban planners attesting to that individual's fitness to practice when he's now actually been qualified. So I think we need to relook how that is interwoven within that particular section. At page 17, clause 27 deals with the issue of appeals to the Environmental Commission. And the appeal process is specific to the refusal of the renewal of the individual's license, an appeal process with respect to the revocation of the individual's license.
Senator Sobers,
yes,
you have 5 more minutes.
Grateful, please. And the appeal process with respect to suspension is here as well too, and the refusal of his reapplication under Section 26. But there's no appeal process indicated in the body of the bill that treats with a person's ability to appeal to any tribunal for a first-time application. So Section 15 or Clause 15 of the bill deals with first-time applicants and a process that they have to go through. And where I thought in Section 27, where we were dealing with appeals, the first type of appeal I would see listed there would have been for persons who would have been refused on their first-time application. It isn't contemplated in this section of the appeal. So I heard the Honorable Attorney General indicating why the Environmental Commission, because there's a small body and whatnot. But I mean, this is totally lacking the contemplation of first-time applicants having a place to appeal to if they are refused to be placed upon the register. And also at clause 29(2), where it indicates that the register shall at reasonable times be open to inspection at the office of the council, the Honorable Attorney General and the government, they love to indicate that they are going digital and that most of these things would be online and whatnot, and bringing things into perspective with respect to the 21st century. So I thought at this juncture we would have seen that the register would have also been online for persons to be able to access to see who are the registered urban planners within our country, as opposed to having to go and actually inspect the registered document or whatever at the council's office itself. Madam President, I again would like to reiterate in conclusion that we need to be more vigilant, more proactive when it comes to addressing issues related to proper urban planning. Not only when it comes to flooding and construction of homes and buildings in areas where they ought not to, but in terms of ensuring, especially in more urban developments, that there's constant assessment of those structures. There's constant assessment as to how persons who currently hold licenses, because it's a license, it's not an unfettered right to remain and exist. It can be revoked. We need to ensure that there's constant assessment that persons who hold those licenses operate within a manner that is responsible, especially when they are serving persons and members of the public within our country. The bill does not properly speak to that, and I think it's something that we should consider, even though we are taking a first step in trying to get this particular position right. That, to me, is very, very lacking in the contents of the bill, and we would need to address that going forward. With those few words, Madam President, I thank you for this opportunity.
Senator Diyal Singh.
Thank you, Madam President, for allowing me to partake in this debate. Madam President, first I might say that recently when we had the recovery team announced, I was a bit disappointed that I don't think I saw any urban planners in this body. And I'm thinking the urban planners are really very important. They're very important, especially now that we have this situation in the COVID, COVID world, that we have the new norm. And remember, they have this skill set, and they have an important role, as well as the healthcare workers, as well as the economists, to see how to get the country going, to see how we are going to plan our cities, how we are going to put things in place, how we are going to, and they should also be in the forefront of this battle, because they are actually, there should be an advocate for a strong voice that could help against the spread of this pandemic and other pandemics that may come. So remember, the urban planners are trained to handle a variety of responsibilities around planning, design, management of land resources, transportation, public spaces, as well as, they would also have the planning in a city to see how it is best for the people in terms of the healthcare, in terms of any sort of problems that may exist. So remember, we have problems with density and the spread of COVID. We have that problem in cities with densities. So therefore, getting the planners into our body, getting them as in more a professional way, we will have to depend on them more and more how to plan our cities. But not all dense cities causes problems, because Los Angeles is a dense city, is a good example, but the neighborhoods are dense, but people can shelter and work remotely and have all the necessities addressed. In comparison, or in contrast to New York, where you see there's a poor dense space where people are forced to navigate between vehicular traffic, roadway, narrow, non-existent sidewalks, are herded into commercial facilities to shop for their basic needs. So I'm trying to give a plug for the importance of this profession, and I have to say it is indeed commendable that today we are now debating this bill to try to get them into that body, to appreciate them more. You see, Madam President, we have to consider the new norm where we have 6 feet apart, public spaces, parks, we'll have to know how we are going to set up shop in the city, and they are the ones who will be giving us that guidance. They are the ones to look at the open spaces, the recreational amenities, and to see how we are going to plan ahead. So the opportunity now exists for housing developers, public policy makers to apply lessons that we have learned from COVID on how to deal with this density. But then, previously, urban planning and regional planning took more for economic viewpoint. Now it should be driven now not too much in the market approach, but by poverty eradication, because that is one of our specific developmental goals, and also health and safety. Madam President, just coming to the Parliament, you pass Beetham, the Beetham landfill, and you realize Trinidad has one of the highest waste production per capita. And even we are running out of space in the landfill. We remember years ago there was, I think when there was a big, there was a summit here, there were plans to block off the wall to hide that area. We look at even sea lots as we are going in there. I mean, Marshall immortalized sea lots in a song, I See Lots. And the thing is, there are those areas around our city, there are those areas that we need to fix. We need to fix the poverty, we need to fix the crime. And I'm saying this is the time that we give this profession the job to do that, to do that job. Because, Madam President, we have to appreciate Trinidad and Tobago. We have had earthquakes, and the earthquakes are getting, people are saying that, we are in for a major one. We have had floods, and flood season is coming on. So all these are efforts that, we would have to address. And all these are efforts, we'll have to see how we are going to best get the spatial density, get the ills that plague our city, how we can get those somehow in a better way that will help our population. So, Madam President, we have a lot to be thankful for. We have the Queen's Park Savannah, which is green space. Trinidad could be a beautiful city. Port of Spain could be a beautiful city. We just have to get together and get our act together. And it is not to say that planning has not been attempted in the past. I remember when the NER were in power, the painting of the lighthouse, that area there, in front of the sea parks, they had benches were put there. They had drained that area where there were shipwrecks. And so attempts were made to beautify. Then later on, we had, I think, when you had the development of Brian Lara Promenade, then you had the Hyatt waterfront. All those are commendable things to make our city nice. But I mean, even though we had that, even though it was plagued with some Udicott scandal, even before that, we had instances where when the Twin Tower, the financial complexes were built, you had all those efforts that made Trinidad, made our city look a little better. But even that was plagued with some sort of allegations where you had the Bala report saying that government-to-government arrangements for that planning were also a little tainted. So urban development is there, but we have to realize when we are developing our country, we have to appreciate that we have to look out for any sort of corruption that may be linked to this. So, Madam President, I would like to say that we have to look at the fact that development of this city, of our city, I think is paramount. We have to look at when they developed Silicon Valley. They had that area, when it was developed in California. You had that area developed in such a way that you blended the communities, the industries, the dominant firms and distinct economies. So the idea is there, you can do things, you can do great things. We can't fix Trinidad and Tobago, and we can also look at the idea that the urban planning, we have to figure that the appreciation has to be given that this profession can help poverty and crime. Because there was research done by O'Sullivan who stated that poor people living close together may somehow continue the cycle of poverty. We also know the concept of broken windows concept where you have certain buildings broken down. So we have an effort there that we need to go after. So all in all, this bill seeks to give the profession, some sort of area where you can have that body, that council, disciplining the members, giving them that authority to make it a body. And I realize that even the University of the West Indies, I think they produce about 8 graduates a year. And most of these urban planners are I think, hired by the Ministry of Planning, and I think they're about 22, and then Tobago there's 12. So it's a field that is there, and it's a field if we're producing 8 graduates a year. We have to think now, when we are putting them in that professional body, we're going to have, and then some are also in private entity. So we have to, to appreciate this is the time to put them in this sort of a framework where they can exist. So the fact that this seeks to establish the council, I think it is something that it's commendable. The fact that certain members had made certain concerns, had mentioned certain concerns about the actual composition of the council. And I too, Madam, may have to say that I too were a little concerned when I looked at the composition of the council, in the sense that I noticed that when you look at the composition of the council, Madam, it was mentioned here that in clause 5 that 4 persons would be nominated by the minister, including an attorney at law with experience in urban and regional planning matters, 2 state planners who are professional members of the Trinidad and Tobago Society of Planners, and 1 person representing public interests. And the remaining 3 persons are nominated by the TTSP. It was made mention that this might be skewed in favor of the minister having more control, and people mentioned that. And as I make mention to this, Madam, even in our medical board, as the president of the medical board, we have a medical board where there are 11 members, and 4 members are elected by in council, are elected by the medical board, and the minister appoints 2 members. So the minister appoints 2, but 1 person who comes on automatically in our medical council is the CMOH, who occupies that position in the ministry. But we also have the Law Association giving us a nominee. We also have the IRO giving us a nominee. And we also have a member of the ICAT, the Accountant Committee, giving us a nominee. And in this way, there's a balance. In this way, yes, the minister has 2 appointees, and the medical fraternity elects 4, but they are non-medical person on board, also to ensure there's a balance from doctors themselves not picking up for doctors when disciplinary matters come on board. So there's a greater balance, 11 members. So therefore I'm saying, somehow, I would have loved to see a more balance into the composition of the council. And as I look at the composition too, I'm thinking, since planning has such a great aspect now in dealing with the post-COVID, probably we may have to factor in that even the CMOH, the county medical officer, Dr. Parsham, or whoever occupies this post in the future, should be factored in there, because the planning, the council itself have to be cognizant of the fact of the health issues, public spaces, public health inspectors, all these things he can bring to the table into this council to make them appreciate not just the structure and the parks and what, but actually more the health issue. When I looked at clause 6, Madam, I realized that this really served to give a code of ethics to register and license the practitioners to really monitor the profession. And so this gives some of the functions of the council. And clause 7 will give the tenure of office, the vacancy of office. All these are actually taken care of. But, what I found a bit, Madam President, is caused me a little concern, is the fact that, you have a licensing committee and a disciplinary committee. And we in the medical council, we do that functions on our own. We don't have separate committees to manage that, because having additional committees would mean more bureaucracy. It may mean more, besides more staff, and I don't know how these members are going to be paid. So you have to look at probably they may have, the minister may have to look at, the AG may have to look at how the medical board and the medical council functions without having these additional committees appointed. But I don't know if it's a new law now that it is a more transparent idea to have a disciplinary committee separate, or to have the not just a disciplinary committee, but a committee who will license separate. So if that is the trend of the law, then probably the Medical Board Act needs to be amended to be in tangent with what's happening now, to come to terms with this. However, when I look at the license committee, I realize that the license committee, the clause 15, speaks of having, the application for license. Somebody coming up for license must have a degree. They must have at least 3 years post-qualification experience in urban and regional planning work recognized by the council. But, Madam President, some persons may come out with a degree and may not get jobs. So we have to know how are we going to factor them in. Further down in the legislation, I heard we have what you call a provisional registration. But the fact is...
Senator Dialsing, you have 5 more minutes.
Thank you, Madam. So the fact is we have to appreciate that we may have to create a position of mentorship with those persons, a paid position, so these young persons may be able to get into the ministry, so we have that future of these planners being there with a job. Because then if they have no work experience, they will just have a degree and nothing to say that they have experience to come on board as full members. Again, I want to look at clause 16, where we are looking to put persons into the list of the professional members of TTSP. And I'm saying people exist right now who call themselves urban planners, who I think the AG mentioned they may be like the bush planners. And when you're changing any piece of legislation, we have to also accommodate these bush planners too, and probably grandfather them in and say, well, you are there already. We will put you in as you're functioning in that role, but after you, nobody will be able to come unless they get their degree from the university. So I think we need to factor that in. To the provisional license, clause 18, Madam, I think in the provisional license actually has applicants not having the requisite experience that they are under the supervision of an urban regional planner who holds a valid professional license and is a professional member of the TTSP. So if these young persons are under those persons, we want to make sure that they are given a job, they are paid well, they are not taken as somebody with a labor you can just, give them pittance. So these people may have to be looked at. They need feedback on performances from whoever is hiring them. For temporary license, this actually looks at persons who are not citizens from abroad. And I think further down in the legislation, it gives citizens that they must come in and give, they must give a character certificate of good character from wherever they are coming. And I suggest also, if they are their professional planning body, should give them a certificate so that there is nothing amiss in their, in whatever job they did there before. Clause 27 had me a little puzzled, and I need some clarity here, where it allows for the appeal to the environmental commissions on a decision of the council to refuse renewal or reapplication of a license, or to revoke or suspend a license. So I just needed a clarification about the environmental commission and how come they would be the one using this, overseeing this. I think sometimes, if somebody is not given a license, there's also the avenue for the court. They can go to court and challenge that also. I look at clause 33, where they said you should publish the list on 2 daily newspapers. I say, all respectively, there are 3 daily newspapers. It didn't cost more, put it in 3 daily newspapers instead of 2. Least the government be accused of they have their preferences in this newspaper and that newspaper. There are 3 daily newspapers. That shouldn't cost more. Now there's a recognition committee, which basically looks at the qualifications. And most respectively, I'm thinking, besides the members there, one should also include a nominee from the University of the West Indies, academic, so to say, who can look in at the qualifications, because the recognition committee looks at qualifications of probably people coming abroad to practice here and could compare the curriculum here with what exists abroad. The composition of the disciplinary committee, clause 44, They said it has to be an attorney of law, at least of 10 years standing, and I'm thinking why? Why among themselves they cannot vote in among their membership who could be the chairman, and also why not include other personnel like a member of the mediation board, because if a disciplinary committee comes about, he may be able to diffuse situation. Further down in clause 46, it was said that if somebody is bankrupt, they cannot be obviously a part member. But how do we know if somebody is bankrupt? Because we may have somebody being bankrupt or somebody abroad who comes in and gets struck off from their role up there. And when they are here, we'd have no idea that they were struck off because of some activity abroad. So somehow we have to have a link between our body and their body. So all in all, Madam, I think that this is a good venture. And in conclusion, I would want to say we need a cleaner city, we need a safer city. And I think this, I dream of Port of Spain being the jewel of the Caribbean, and I hope one day this could be achieved with this body. Thank you.
Leader of Government Business.
Thank you much, Madam President. Madam President, I beg to move that the Senate now adjourn to Tuesday, the 9th of June, 2020 at 10 a.m. We plan to complete the committee stage of the registration of bill, and time permitting to complete the debate on this bill, the Urban Planners Bill.
Honourable Senators, before I put the question on the adjournment, leave has been granted for two matters to be raised. Senator Mark.
Madam President, thank you. Madam President, I've been advised by Senator Clarence Rambarat that the Minister of Finance is otherwise engaged, so he would not be able to present himself to respond to my motion. So, with your leave, Madam President, I shall defer that matter for next sitting. That is what I've been advised. Madam President, the matter that I'll be discussing and seeking some clarification on is the need for the government to outline what steps, if any, it will be taking to immediately assist the hundreds of TNT, Trinidad and Tobago nationals stranded in different countries and on cruise vessels who are desirous of returning to this country. Now, Madam President, I cannot provide this Honorable Senate with all the instances of persons, groups in different parts of the world, in different countries, on cruise line vessels who are seeking to return to Trinidad and Tobago. But there is need for the government to outline in a very clear manner through a policy document what is the policy of the government and the process involved in a transparent way as it relates, Madam President, to the granting of exemptions to different categories of persons in Trinidad and Tobago, or who are desirous, I should say, in returning to Trinidad and Tobago. You see, in the absence of a clear policy that is published, Madam President, and circulated, no one in this country will have a proper understanding of how this process is activated and executed. Lest, Madam President, citizens come to the unfortunate conclusion that there may be some discrimination in the actions that is being taken as it relates to picking and choosing who should be returning to our country. So the first point I would like to record, Madam President, is the need for the government to circulate for public consumption its policy as it relates to citizens who are stranded abroad and who are desirous of returning to their country. Madam President, there are so many instances of citizens who have been appealing to the Minister of National Security for them to be granted an exemption so that they can revisit, or they can return, I should say, to their homeland. Some of them, Madam President, are not in a fortunate position to pay their way. They are literally bankrupt financially, and they are depending on the government to intervene and to bring them back home. Some of them, Madam President, or I should say others, are in a position to finance their own way, even to the point of paying for a private aircraft to bring them home, Madam President. So I am raising this matter today, Madam President, to get from the Honorable Minister of National Security, how does the government proceed in dealing with all of these nationals who are willing to return? I will give you some examples, Madam President, in order to demonstrate the challenges that these citizens who are outside of our space, land space, and are located in other jurisdictions are experiencing grave and dangerous challenges. I myself was moved not to tears, but my paws raised when I listened this morning to the pleas, the cries of one Mr. Patrick Jaglal Singh. He is a visually impaired person who, unfortunately, Madam President, went to St. Lucia, and whilst he was in St. Lucia, we closed the border, or the borders. And Mr. Jaglal Singh is appealing to the Minister of National Security, and he has done it on several occasions. I am speaking after what the gentleman said on the radio this morning, that he has made several efforts to contact the Minister of National Security to get the minister to agree to bring him home. He is saying, Madam President, by the 4th of June, which I guess is today the 4th? Tomorrow. He is saying to us, Madam President, that the persons who he was staying by would be leaving for Texas because St. Lucia is opening its airports and they are going to Texas, and he would be stranded. So I just draw this as an example, Madam President. We have a citizen who is visually impaired. He is crying out for help, and he's not getting any responses from the Minister of National Security as to whether the government would be willing to arrange a flight or to let him get some funding because he's stranded. He needs to come back home. So that is the first person I wish to bring to your attention. Madam President, that is a person who cannot afford to pay his way back to Trinidad. But Madam President, I too was a bit surprised, like I'm sure many of us, when we read in the Saturday Express of May the 23rd, when a citizen who is a businessman by the name of Mr. Jeffrey Azar, who complained, Madam President, that he was shocked, even though he is able to pay his way. And he was able, Madam President, to pay almost 3/4 of the monies required for a private aircraft to bring him home with his wife, who went, according to this report, for treatment for cancer. And Madam President, this gentleman, from my information, and maybe the Minister of National Security can clear the air, on this matter. This gentleman is still languishing in Miami, and he's with his sick wife, and he has been making appeals after appeals to the minister to have him come home. He's not asking for Carl to go to New York or to Miami to pick him up. He's willing to get a private aircraft to take himself and his family back home. So, Madam President, here is another example of a citizen who is able to pay, but he's still unable to be granted an exemption to come home. This is why I am asking today, what is really the policy of the government when it comes to dealing with our nationals who are stranded? And Madam President, you would know many people have medical emergencies. Many people, based on the research that I've conducted, are stranded on cruise lines or cruise ships. Some of them are in Curacao. Some of them, Madam President, are in the United States. Some of them are in Europe, and they want to come home, Madam President. And therefore, I am raising and I'm seeking clarification from the government of Trinidad and Tobago as to how we are dealing with our nationals. Our nationals believe that they are not being treated fairly. They believe that they are not getting adequate responses and timely interventions on the part and from the government. So, Madam President, this is my simple motion, and I would like the Honorable Minister of National Security to guide us on this matter and guide Trinidad and Tobago on the government's policy on this matter. I wish to thank you, Madam President, for the opportunity.
Minister of Agriculture, Land and Fisheries.
Thank you, Madam President. Madam President, thank Senator Mark for the motion. I want to emphasize from the outset, Madam President, that it is clear that the government has successfully managed the country's response to COVID-19. Compared to some of the more resourced jurisdictions, we have done well under the leadership of our Honorable Prime Minister, our Minister of Health, the Chief Medical Officer, all the healthcare practitioners, those based in Trinidad and those advising from the outside, and all the other persons, all the other citizens, Madam President, who have done what they were required to do. Madam President, perhaps the most difficult measure we've had to take, we've taken several measures, including stay at home, wear your mask, and other things. The most difficult measure must have been closing the borders. And even the Honorable Prime Minister has spoken about his daughter having to remain outside. Because not only for us, jurisdictions which have had success, a major part of the success has been the closure of the borders. And we've done that since March 23, 2020, to both nationals and non-nationals. Madam President, the government believes that a significant component of protecting the population and the success we've had so far has been through the closure of the borders. And we don't have to go far to justify this. Every single one of the 117 positive cases of COVID-19 in Trinidad and Tobago, every one was imported or traced to importation. We do in fact recognize that we have nationals outside. That is the nature of all these Caribbean islands. We have significant sections of our population outside. And in this case, the Minister of National Security has indicated, and they're outside for various reasons, Madam President, including those who work outside of Trinidad and Tobago, like offshore workers in the oil and gas industry, people who work on rigs, people who work on service boats, servicing rigs in the Gulf of Mexico, in Suriname, other parts of the world, people who work on vessels, people who work on cruise ships. Throughout the Caribbean region, we've been hearing a lot about the cruise ships and the impact of COVID on the cruise ships. But the Minister of National Security believes that there are 330,000 nationals outside of Trinidad and Tobago, and thousands of them wish to return to the country, and thousands are seeking approvals to re-enter Trinidad and Tobago. And towards the end, I will talk about the press release from June 2nd that outlines a process. Madam President, the government has continuously provided information with regard to the controls at the borders, the closure, the way in which it is being managed, and the reason for doing that. We've moved from daily press conferences to a position where we have a few press conferences each week. But initially, at least for the first month, there were press conferences every day. A lot of information via the Ministry of Communication, my colleague Donna Cox, Senator Donna Cox, and various technocrats from the ministries have appeared at the press conferences, including my colleague Senator Paula Gopi-Skoon also. So there's been no shortage of information. Madam President, what the Minister of National Security has been articulating is that from time to time, permission may be granted to persons to enter or to leave Trinidad and Tobago. And we don't focus too much on leaving, but because the airports are closed to commercial aircraft, there's also the need for the minister from time to time to facilitate the landing of aircraft for transport of persons outside of Trinidad. For example, the various embassies, the British Embassy and the US Embassy, have had flights for persons working in Trinidad and for persons who were in Trinidad and Tobago and were required to leave. So the process has been the minister receiving those requests and exercising his authority in consultation with the Ministry of Health and the Prime Minister in relation to exit and entry of nationals. The government has been permitting nationals to come back to Trinidad, but it has done so in a very controlled manner. And in the case of persons entering, the key element has been on the basis of risk assessment and on the requirement of quarantine. And for that purpose, Madam President, we've established quarantine facilities where persons returning to Trinidad by permission are required to enter into these quarantine facilities. Madam President, in relation to the cruise ship workers, it was very topical, it was in the news, there were a lot of pleas and so on for the re-entry of those workers. And the first batch of 6 nationals were allowed back into the country on Saturday, 23rd May 2020. And 2 days later, there were 52 nationals who worked on cruise ships who were permitted entry, and they're all in quarantine still in accordance with the procedure and the guidelines which have been established. But I take the opportunity to say, Madam President, that cruise ship workers who were repatriated to Jamaica, Grenada, and St. Vincent have actually tested positive for COVID-19. And some of our nationals who were on board the same vessels as those persons who have tested positive and re-entered those other Caribbean jurisdictions. Madam President, the government is now making arrangements for another 29 nationals working on cruise ships to enter Trinidad and Tobago tomorrow. The Minister of National Security and a team are currently in discussions with one of the largest cruise ship companies, Royal Caribbean, to manage, and there's been a lot of discussions on this particular one, to manage the return of between 326 and 350 of our nationals who are working on the Royal Caribbean ships. And Madam President, the point that
the Minister of National Security, the Prime Minister, and the Minister of Health have been making is that the re-entry and quarantine of this particular group requires significant logistical arrangements, as the re-entry would really put pressure on the existing quarantine resources, and also, in the event it becomes necessary, would put pressure on the other elements of the health sector that provide support in our response to COVID-2019. So those discussions are taking place with the Minister of National Security, of course, in consultation with the Prime Minister and the Minister of Health, and of course the Chief Medical Officer. The government is also working with the principals of UE in Barbados and Jamaica, Madam President, to repatriate our nationals who are at UE in those countries. And again, the initial figures suggest that there are about 600 nationals of Trinidad and Tobago who are in Barbados and Jamaica. And again, the need for quarantine and the need for additional measures, and of course the need to ensure that we have the capacity in case some of these returning nationals who are coming from UE in Barbados and Jamaica need additional health support having regard to where they're coming from. So all nationals returning are assessed by the Chief Medical Officer, and a determination is made on what needs to be done in the context of quarantine. But the government remains mindful of the stress. We've avoided great difficulties so far. We know what our capacity is. Government is making sure that we do not put the sort of pressure that other jurisdictions have put on their health capacity and found themselves in grave difficulty. Madam President, there was a press release on June 2nd from the Minister of National Security, and the media release sets out the procedure for requesting an exemption to enter or depart from Trinidad and Tobago, enter into. And basically, it sets out that at this stage, only requests made by nationals and permanent residents of Trinidad and Tobago to enter the country are being considered at this time on a case-by-case basis.
Minister, your time is up.
Thank you very much, Madam President.
Honourable Senators, the question is that this Senate do now adjourn to Tuesday, the 9th of June, 2020 at 10 a.m. Those in favour say aye. Aye. Those against say no. I think the ayes have it. This Senate now stands adjourned to Tuesday, the 9th of June, 2020 at 10 a.m.